law professor Dru Stevenson on Supreme Court oral arguments in Mexico's case against Smith & Wesson. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also a CNN contributor and the founder of thereload.com, where you can head over today and sign up for a free membership if you want to keep up to date with what's going on with guns in America from a sober, serious perspective that focuses on hard news and analysis over bloviating and opinion, I guess. This week, we are going to be talking about the Supreme Court's oral arguments in Smith & Wesson v. Mexico, a big case that they just heard this week. So to do that, we have someone back on the show from the South Texas College of Law, Professor Dru Stevenson. Welcome back to the show.
Thank you for having me. I'm glad to be here.
Appreciate you coming on to give your perspective on this. Before we get started, can you just give people a little bit about your background for anyone who might not know you?
So I'm a law professor. I teach legal ethics and also regulatory law or administrative law and law and economics. For the last 5 or 7 years, I've devoted my research and writing outside of my classes to firearms policy and firearms regulation. Most of the people, honestly, who write about this issue academically are focused on constitutional questions and rights. And I approach it more from someone who has studied the federal bureaucracy a lot and how regulations work and how things get made and interpreted and enforced. And so I like to study it from a regulatory perspective, not just a rights perspective. Although that's also important, and there's a lot of people who cover it consistently from that angle.
Sure.
Yeah.
And this case actually is not a Second Amendment case.
That's right.
Right? Not really, at least. Smith & Wesson made some Second Amendment adjacent claims in this, in their brief, but and you could argue that the potential fallout could have an effect on people's ability to buy guns or what have you. But mainly, this is a PLCAA case, essentially,
That's
Protection
right.
of Lawful Commerce in Arms Act case about whether or not Mexico, the government of Mexico, can sue Smith & Wesson and other gun manufacturers in America for liability related to crimes that happen in Mexico
Right.
with guns made by those companies. Right. So you just set up the sort of background and how we get to this point of the Supreme Court even hearing this case. What exactly is that issue, and what is the bar? Like, what stage of the case we're in? Not this, because it's not the merits, right? We're not talking about evidence and all that.
That's right.
At this point.
So, and on your point, several of the gun cases that have gone to the U.S. Supreme Court in recent years have actually not been Second Amendment cases, but I recognize that there's a certain group of people or thinkers who view every gun case as a Second Amendment case. But Vanderstock last fall was not a Second Amendment case.
That's the so-called ghost gun.
The ghost gun, right? That's a
regulatory
regulatory case. The bump stock ban case was regulatory, and the NRA versus VULO was a First Amendment case, not a Second Amendment case. And so
Right.
it is important to keep in mind that there are legal issues about guns that are not just the Second Amendment. And in this case, if I can just back up a little bit about PLCAA and the statute and how we got here. In the 90s, in the early to mid 90s, there was a case against the tobacco industry that was brought by a coalition of a lot of the state attorneys general. And this was over the state's costs in providing medical care for people who had been smokers. And so people had tried suing tobacco companies individually for years and years before that, and unsuccessfully, because they had made a choice to smoke. And but the states don't make a choice about whether to have people smoke, and they end up footing the bill for a lot of the social costs of the healthcare. So what happened was they got this enormous legal settlement and judgment out of the tobacco industry. And that case was kind of monumental for our legal system, regardless of what you think about the merits of it. So what was happening was a lot of people in the legal system looked at that and said, well, we've had congressional gridlock on a lot of other issues like the environment or gun policy and things like that for years. Maybe we should try suing. And so what happened is some of the our large cities that have a lot of crime started to bring lawsuits against the gun manufacturers for basically flooding the streets with and contributing to arms proliferation. And they got a couple of settlements from gun makers, and the gun industry got spooked and went to Congress in the mid-90s and said, we need statutory immunity. And they weren't the only industry that did this. Around the same time, rental car companies were getting sued for because there was a disproportionate likelihood that people, when there were traffic accidents and traffic fatalities, that one of the person who caused it was driving a rental car. And so Congress had this kind of series of issues that they decided to grant immunity to an industry for a lot of the lawsuits. And guns was one of them. And that's where we got the Protection of Lawful Arms and the in Commerce Act and or Commerce and Arms Act, I'm sorry. And they since then, and it did end a lot of the litigation, especially by big cities against the gun manufacturers.
Right. The argument on the industry side was that these were frivolous lawsuits,
right?
That they cost them a lot of money to defend, and they shouldn't be held responsible for the criminal acts of the parties. That was the debate, and Congress passed this law. But that the law does have, and that's very relevant to this particular case, right? Some exceptions.
It does have some exceptions. And so you're still allowed to sue a gun manufacturer under one of the exceptions if your gun is defective. So, right. So there was a kind of wave of lawsuits against Sig Sauer in recent years over one of their models that would tended to fire accidentally and things like that. And so people would get injured, or if somebody made a gun that 1 time out of 10 blows up in your hand when you shoot it, you could still sue the manufacturer. Right. And then and then there's a couple other exceptions. So if a gun manufacturer is clearly violating state laws, so for example, they are not registered to operate in the state, they're selling, shipping to unlicensed dealers or people who are, not supposed to be buying guns and so forth, that they could be held liable for that as well. And when they were debating the statute, this was one of the concerns and a promise from the bill's sponsors. No. If a gun manufacturer actually is breaking the law or doing
or a gun
kind
dealer or somebody like that.
or something like that, or a dealer, then we can, they will still be responsible for that under our legal system.
Right.
And the concern is, if I can make an analogy kind of to a product that we all use, a cell phone, but there's a segment of that series, Better Call Saul, where he's down on his luck and he's selling burner phones to drug dealers and sex workers and stuff like that for a highway overpass, right? So he goes through this phase where he is clearly knows that he is supplying the criminal underground with burner phones, and whether, even though that's not illegal, I think we can at least see why people would question whether that's good policy to allow that. And so we get this one exception that's called the predicate exception, that basically says that if you are aiding and abetting another person in a crime and are the proximate cause of the harm, then you don't get the immunity from lawsuits that PLCAA provides.
Right.
And so some sort of knowing cooperation. So Mexico, a couple of years ago, brought this claim that basically there are hundreds of thousands of guns flowing across the border every year into Mexico. And so just like there's immigration coming north and drug trade coming north, there's guns to the cartels coming south, and their law enforcement agency, their federal police, when they clean up after a crime scene, if they recover arms, by their claims, 70% of them are coming from the United States, are from American gun companies. And what they will do is they contact ATF or the NIBIN system to do a gun trace, and so which means that the gun companies get notified. And so they are definitely aware of the scope of how many guns are ending up in Mexico. And this is an illegal trade. Mexico has pretty strong gun laws and only one government authorized gun dealer in the country. And these guns are not coming through the legal channel. On the other hand, as we all know, the central government of Mexico is weak in comparison to the power and strength and resources of the cartels right now. And they would argue that part of that is our fault, is the fault of the American gun manufacturers for arming the cartels.
Right, that's Mexico's argument in this case.
Yeah, is the cartels are getting armed on the level of ISIS or Hamas or something like that from these straw purchasers. And then the second piece of their case is that
straw purchasers being people who go to American gun stores and lie about who they're buying the guns for. So that's what a straw purchase is, right?
That's
Somebody
right.
who doesn't have a record goes and commits this crime of lying to obtain a gun for somebody else. In this case, somebody connected to the cartels, and that's how they will often obtain firearms, across the border.
Exactly. And
that's a big part of this suit, right?
It is. And this has been a longstanding problem. The gun dealers, like a lot of industries, they're not unique in this. There's kind of a bad apple problem, right? So there's about like 95% of the crime guns or 90% of the crime guns are coming from a handful of rogue dealers or negligent dealers who aren't really trying to screen for straw purchasers. And
this is another point of contention, right? In this lawsuit and generally.
In the lawsuit and generally, the recognition is, so look, I'm not a fan of civilian arms proliferation and wish we had fewer dealers, but I will also concede that most dealers are trying to comply with the law and follow the rules and so forth. And then there's a handful who don't care. And so this is what Mexico argues, is that different reporters have tracked this down over the years. There's been a number of investigative journalism stories about the kind of dirty dozen arms dealers near the border or outside of Chicago in Illinois and so forth. And they can also tell the gun manufacturers from their shipments that an incredible number of, let's say, assault rifles are going through one kind of small dealer in Brownsville or someplace like that, or Arizona. And so it's kind of an inference. How could they not know that exactly who the bad dealers are, and that this is the kind of pipeline or channel for the guns to get to Mexico? And so they're not asking them to implement gun control nationwide or something like that. Well, they're basically saying, I understand that that's a counter argument.
There's other things that they're saying as well, just making those types of guns in the first place.
So there's certain types of guns that they think are designed to appeal to the cartel, that have logos of the Mexican Revolution embossed on them and stuff like that.
And
are kind of and have a lot of bling and stuff, right? We're not talking about your standard Glock that a lot of people buy, but the bigger part of their case, really, they could drop the claim, I think, about marketing product design. I think that's actually probably the weakest part of their case, and just focus on the fact that manufacturers should have a responsibility to cut off retailers if there's a lot of reason to think that retailer is breaking the law and breaking the law a lot.
Well, and that's where so that's sort of their main argument, right? On the Mexico side for the Mexican government. Now, obviously, Smith and Wesson's counter argument focuses mainly on the disconnect between the actual claimed harm in Mexico, having to pay to deal with the gun violence that occurs there, carried out by people breaking the law,
right?
And their actions, which is the manufacturer of the guns in the first place, and then the sale because the other thing is that Smith & Wesson doesn't sell directly to gun dealers either. Right. So the chain here is Smith & Wesson makes a gun, they sell it to a distributor, wholesaler. The wholesaler sells it to a retailer. The retailer sells it to what turns out to be a straw purchaser, who then gives it or sells it to the cartels, who then carry out the violence that. So their argument is that this is too far removed. No one is even being charged with crimes along this chain that they're talking about. It's not like Smith & Wesson is continuing to sell guns or the distributors to dealers who have been arrested for, participating knowingly in straw purchases. That's the counter argument here, right? That's the main counter argument. The main argument
is there are too many intervening actors here, and so the fact that I'm a car company, let's say, and I manufacture a car, and it ends up at a used car dealership, which gets bought by somebody who sells it to somebody across the street, who then sells it, and 6 steps later, it's used as a getaway car in a crime. Right. Or to run somebody over. That's their argument. I will say and then the problem with this, and this isn't the only area where we have this problem with, there's a lot of areas of criminal law where you get a conspiracy, like in the drug trade, and they do precisely this on purpose, right? So they will have the drugs get passed through several steps so that it makes it harder to trace things to the cartel, the drug lord or the cartel leader or gang leaders or so forth. And so if we say something like 6 steps removed is where we draw the line, then people who are engaged in a large criminal enterprise will just have a 7th step every time to insulate themselves from criminal liability. Now, about the procedural
point is
steps,
that you have to show that they were knowingly doing this, right?
Yes. And
at least for criminal liability, I guess this is maybe the difference here is that this is a civil case.
And that's part of the problem, is that this is a confusing area of law where we have a civil statute that has an exception that's based on criminal law concepts. And as you know, criminal law requires a different burden of proof beyond a reasonable doubt and things like that. Depends on prosecutors' resources and so on. And and then we have some of these undefined terms like proximate cause and what really counts as aiding and abetting someone else's crime. This isn't the only area where those questions come up, of course.
Certainly.
Yeah.
And that's, part of the thing with the Supreme Court is that they're usually not deciding a case just to decide that one case. They want to put some meat on the bone for these other issues at play, proximate cause and things that in most cases. So that's the dispute. I think that's a pretty fair summary of what the basic, there's more to it, but that's sort of the basic arguments on either side. What's the standard that the Supreme Court is looking at in this case now?
So so what happens is Mexico gets into district court, and the district judge dismissed the case and basically said, sorry, the gunman, this doesn't fit within one of the exceptions under the statute. Right. And Mexico appealed it to the First Circuit, and the First Circuit said, actually, they're at least the stuff they're alleging at least could fall under the predicate exception.
Because that's an important point, right? At this stage, they have to, this is similar to the NRA case, right?
It is.
They have to accept whatever the plaintiffs are pleading as true. Like, if this is true, and we're going to assume it is at this point, then yes, your case can go forward, or then no, it still doesn't work. That's basically what we're talking about here.
That is. And that was you are absolutely right. That was the case situation in the NRA versus VULO.
Mhm.
And here, so it's not enough to just make sort of vague generalizations. So we're going to take it as true, but you have to, the flip side of that is your accusations or allegations have to be specific enough to sort of sound so we know what kind of evidence to be looking for in the case.
Right.
And that's what a lot of the oral arguments were about yesterday.
But the lower court, as you said, it went to an appeals court, and they said this case is okay to move forward. And their ruling was based on this idea of foreseeability, that
Right.
because it was foreseeable that, when Smith & Wesson makes a gun, they know that this chain is going to happen, even if they don't sort of actively participate in it necessarily. They're not encouraging it to happen, but they can foresee that eventually some of their guns are going to end up in Mexico under the way they do business, and therefore it can go forward. That's just a sort of summary of what the lower court said.
That's right. And I mean, we're not talking about a handful of guns. We're talking about tens of thousands or hundreds of thousands of guns a year. And so that's something that isn't just a write-off on the budget spreadsheet. This is a big dollar item for guns that are going to the border states. The issue here, though, that I hope your viewers pick up on is we haven't had a trial in this case. And so on the one hand, Mexico, even if this hadn't gone to the Supreme Court, the First Circuit had sent it back and said, look, you need to start moving towards a trial. And that means Mexico actually has to prove their argument, that they have to start putting on enough evidence to make it at least more probable than not that the gun manufacturers or their executives know enough of what's going on and have made enough deliberate choices to keep it going that they should be held responsible. And that's going to take a lot of evidence. It's going to be an uphill battle, but they didn't even get a chance to do that. So I do want to say, even if they won at the Supreme Court, which I don't think they're going to, but if they did, then it goes back to trial, and they could still lose at trial. And that could still happen with the NRA and VULO, right? That case is in discovery right now.
Mm-hmm.
And there's some early indications the NRA might actually have trouble proving some of what they alleged. And so if you're going to go to trial, you've got to put on evidence. It can't be just stuff people read on the internet. It has to be admissible evidence in court that can be verified and so forth. And so Mexico would still have to do that. And all they're really asking is for the chance to do that.
Right.
And
to be fair, that is that's the standard, and that's the stakes that we're talking about.
It is.
And obviously the argument is on the other side of it is the whole point of the PLCAA was to prevent these kind of lawsuits, because even if they fail on the merits eventually, they still cost a lot of money to litigate.
They cost a lot of money, and so a lot of times companies will just settle to make the case go away.
Right.
And so it could incur, and they have a valid argument that this could open the door to other lawsuits or encourage other lawsuits. Maybe now Mexico is a special case because you can drive guns across the border, but maybe the next place would be the Bahamas or Guatemala or something like that would suit them.
And America makes a lot of guns that end up in a lot of places all over the world.
That's right. And I will concede that most of the guns made and sold in America don't end up being used in crimes.
Sure.
And so I'm not a gun guy, but I think that it's important to concede that this is a fraction of the guns that are made.
Right. Certainly. But so, I think we've gone through a lot got the details of what exactly is being claimed in this case. Now I want to get into what happened at oral arguments, right? Because, you noted there that you don't think that Mexico is necessarily going to come out a winner on this case. One of the reasons I wanted to have you on is because I think a lot of the initial reaction to oral arguments and my own reaction to listening to it was, this may be a lopsided win for Smith & Wesson. And, it's not just Smith & Wesson, it's like a bunch of other gun companies too. But it felt like there was a lot of skepticism that this about Mexico's argument here, about the specificity of it, about whether it really does clear those exceptions that are in the PLCAA, or if it's just they're just trying to make a workaround. And it came from you even heard some of those points made by some of the more liberal justices. So I'm interested in having it, because one, you clearly have followed this case very closely, and you listened to the oral arguments. You did a thread on this on Blue Sky or on one of the social media sites. And I just thought wanted to hear your thoughts, because I feel like you're taking a little bit of a different view than what I've seen in a lot of other, even just the regular, legal news outlets that have covered this, feel it's going to go significantly one way. So let's get into the oral arguments. What was it that stuck out to you?
So first of all, I disagreed with a lot of the other headlines and takes that the justices, I think Bloomberg Law or somebody said at Law 360 that the justices seem poised to rule against Mexico and stuff like that. I don't know. I listened to it. I read the transcript, a lot of it, and they were not. So the reason I think it's a little unlikely Mexico is going to win, or is that there was no one who among the justices, even the liberals, who were clearly really signaling that they were on Mexico's side. And usually we get that in these these cases that split on party lines. We'll have a couple people on each side who are clearly kind of trying to make the case through their questions.
Yes.
For the side that they favor.
You do get a lot of that, yeah.
That, and I didn't. The closest we got to that, I thought, was Justice Gorsuch threw a softball question at Kate Stetson, Mexico's lawyer, giving her a chance to answer, explain away a case that the Smith and Wesson's lawyer had really focused on. And so there were a couple of softball things like that, but not any of the sort of sermonizing through questions that we usually get from the people at the two wings of the court. And so I thought that was bad news for Mexico. That's an
interesting point, though, because as much as I do want to caution people, right? It's good to caution people that what happens in oral arguments does not always give you a full understanding of how the court is actually going to come out in written opinions.
Right.
But it is often pretty easy to tell when a justice has already made up their mind, right?
That's right.
And maybe we didn't see that much of that in this particular case on either side.
We really didn't. I thought that they, in some ways, I thought across most of them were actually could see why the legal questions that they had agreed to talk about, proximate cause and aiding and abetting, are really kind of brain teasers or puzzling, and they are aware that there could be implications completely apart from lawsuits against gun manufacturers for what they say. So here's my counter take, though, is that I also didn't pick up hostility towards the Mexico's case, outright, you've got to be kidding me, or acting like their claim was laughable or ridiculous, and at all. And so instead, what I picked up is that they were they thought that Mexico's case their pleadings weren't specific enough,
yes.
But that they really didn't want to narrow the predicate exception in a way, a lot of them, in a way that would make it hard to sue a rogue dealer or somebody that's selling to gangs here in the States. And so there were questions from Gorsuch and Amy Barrett that, Amy Barrett kept harping on this issue of, but even so, if somebody sells to a bad guy, they could still, and they know it, and they intended to do it, then they could be held liable. And so I think that some of the conservatives on the court want to have an ability to hold the true bad apple gun dealer or gun manufacturer responsible. And so what I'm expecting is, I don't think we're going to get a unanimous opinion like we did in NRA versus Vulo. I think we're going to get a whole bunch of concurring opinions, and maybe a dissent from Sotomayor. But and
what makes you say that about Sotomayor? What are your
because
thoughts there?
she brought up this. It was her kind of one of her final comments in the oral arguments. So she just kind of came out, and after asking a few questions, said that she doesn't like the doctrine of foreseeability for proximate cause. That she said it just doesn't.
The lower court was talking about in this case.
That it doesn't do anything for her. That's the phrase she used. There are conceptual problems because when you talk about what do people know, we don't have a way to read people's minds, and especially not in the past. And so she didn't like that. There's a treatise or sort of a thing called the Restatement of Law that's like a model statute for torts that she wanted to use, that uses a scope of the risk test. And so that's all fine, but she really belabored the point to where it became clear that she's going to write a separate opinion about the scope of the risk test. I think that's what I'm expecting.
And what is that exactly?
It's basically saying, so what is the risk of the activity you're doing, and is this harm falling within that sort of as objectively? Not did you know or have reason to know, which would be foreseeability, but and then she said, and I think that what is happening with Mexico falls within that. So maybe we're going to get one. That was the most closest we heard to somebody maybe signaling that they were sympathetic to Mexico's case. But I got to say, in the first part, but in that case, she would still be reversing the circuit court opinion, which is go against Mexico, and saying, but the reason I'm reversing is because I think they used the wrong standard for proximate cause.
Okay. And so you see that a lot for the liberal justice in this case, maybe?
Yeah.
Some of the conservatives.
And so the Justice Jackson kind of was, of all the justices, I think she gave the Mexico's lawyer the hardest time.
Let me give a quote from her real quick. Because I agree. And this was one of the things that was surprising, and one of the reasons that I thought maybe this will be kind of a lopsided ruling against Mexico. Because Brown Jackson said, I guess I'm just, here's the quote. I guess I'm just wondering whether the PLCAA statute itself is telling us that we don't want the courts to be the ones to be crafting remedies that amount to regulation on this industry. That was really the point of the entire thing, to the extent that we're now reading an exception to allow the very thing that the statute seems to preclude. I'm concerned about that. I mean, that is a pretty strong statement, right?
It is. And I was surprised by that. But I wondered, to be honest, if she views this case as kind of a lost cause, and is laying the groundwork for the many cases that are in the pipeline right now that are about what the Trump administration and Elon Musk's Doge are doing with dismantling, defunding and dismantling federal agencies and programs that actually were authorized by statute, by Congress, and funded by Congress in previous budgets. And so now, we're supposed to have some sort of separation of powers. And the thing that made me think that is that she kept talking about, we have to be faithful to what Congress wanted and what Congress intended. And
so you think she's saying more than just what's going on in this case?
I think she was starting to make her argument for all the cases about U.S. aid and the Securities and Exchange Commission and the CFPB that are already in court, right? There's 80 cases at least already in court about that. And it's going to come down to a pretty big question about how much do statutes matter, or does the president get to thwart the intent of Congress if the current Congress lets him? And so I did think that.
Because one of the other interesting things about her questioning,
Yeah.
too, because she was pretty strong questioning the lawyer from Mexico, but she was also fairly strong in questioning Smith & Wesson's lawyer, specifically about the definition of aid and abet as it relates to the PLCAA in particular. She seemed to be arguing that maybe, or at least questioning, and this is where, this may be just something where she doesn't have a firm view on it, and she's wondering, and actually legitimately questioning the parties here. But, she seemed to think maybe a definition of aiding and abetting in other circumstances is not the same as in this statute. What did you make of that?
So, in some ways, I was surprised that the other justices didn't talk more about this problem, that we have a civil statute, as we said earlier, that incorporates this criminal law concept of aiding and abetting, right? So you buy the gun or drive the getaway car for somebody who commits a crime, that you're aiding and abetting, or you provide a safe house for them to hide from the police. That's aiding and abetting. But where you draw the line for what counts as aiding and abetting actually it doesn't just vary on the facts. It might vary state to state and in the federal system a little bit, depending on which statute we're talking about. And so I'll give an example. We have a federal statute against material support of terrorism for foreign terrorist organizations. And we've had some cases go to the Supreme Court where they were pretty strict about even giving legal advice to a foreign terrorist organization about how to go legit and become a legitimate political party in another country could still come under material support of terrorism. And so I think her point is that this is a statute. We have text, and we could be strict textualists about this and say we're not deciding aiding and abetting for every criminal case that's out there for drugs or immigration or everything else. This is only for what it means when we're applying the predicate exception under PLCAA. And there is some logic to that. And again, that's something that's very hard to predict from yesterday's oral argument, where the other justices are going to come down on that. I thought
it did seem like a lot of them, even the liberal ones, were concerned about, you mentioned this earlier, specificity, right? Like, because the Mexican complaint doesn't mention, it has the structure that we talked about earlier, and this idea that because there are traces that happen from crime scenes in Mexico that go back to the manufacturers to try and figure out how the gun ended up where it did, that they have some knowledge that their guns end up in these crime scenes. It's sort of a general that they must know then that somewhere along the line somebody is doing something wrong, but they didn't have any actual specific examples of anyone. They didn't point to any specific gun dealers or any. There were no crimes. Nobody's been arrested in this chain of events that they could trace back to having, some sort of direct connection to Smith & Wesson or the other gun companies involved. And that seemed to bother a lot of the justices, right?
It did. And there's a couple different ways to take that, though. And so on the one hand, near the end, and I don't know why she took so long to work around at this point, Mexico's lawyer, Attorney Stetson, did point them to a few pages in the complaint. The complaint's very long, right? She said, so paragraphs, 241 or something to 259 do give some specific examples and mention dealers, but I don't know why she didn't lead with that, because they've been talking about it the whole time up to that point. The other thing that, and I said this in my thread on Blue Sky, the single biggest surprise to me about the oral arguments was that Mexico has a parallel case against specific gun dealers pending in Arizona, which is actually kind of currently on hold, awaiting for what happens in this case. So it's two related cases. When I gave a presentation to the faculty of my law school about this case a few weeks ago, this was a question I that everyone kept asking me, why don't you just sue the dealers, right? Why the
Right.
manufacturers? Well, they are suing the dealers, and that case is moving very slowly and is probably in suspended animation at the moment. And I don't want to criticize Kate Stetson because she's better than I would ever be at what she does, but I wondered if she was brought in just to argue at the Supreme Court and wasn't aware of the parallel case that Mexico has in Arizona, because that would have been the easy answer is, oh no, we're suing we're suing specific dealers too, but for jurisdictional reasons, we can't get those dealers in court in Massachusetts. We're suing them in Arizona. We're suing the manufacturers in Massachusetts.
Right.
And so that would have been the easy answer. And I don't know why she never got around to that.
And I think Thomas also sort of objected to the idea that, that this sort of, without criminal charges against any of the people involved in this chain, can you really say that anyone's being aided and abetted at all? I don't know. What did you make of that?
So I thought that
was
was weird. And I'm expecting a kind of sort of a Justice Thomas special where we get this sort of quirky concurrence or dissent advocating for something pretty radical, like no one should ever be held liable for aiding and abetting unless there's a prior conviction or a predicate conviction first. Well, it doesn't always work that way because, for example, we could have someone who has committed a crime, but they make a deal that they're willing to testify against someone else. And so they get put in witness protection instead of sent to jail. But they still had people aiding and abetting them, right? We also have situations where, let's say you help someone rob a bank, you help them plan a big bank heist. And so you were aiding and abetting, and then they get shot during the attempted bank heist, as an example. Well, then there would be no conviction, right? We don't convict dead people, but we could still come after you for aiding and abetting, even though there was nobody else was arrested for the crime that you aided and abetted because they're dead or they have disappeared. They've fled the jurisdiction. We can't find them. Or as I said, they made a deal or something has gone wrong. Their case is being delayed. That person, something like that. So there could be a ton of reasons that we have never really required that for aiding and abetting, a prior conviction that's the basis for the case. If I can, since we're talking about Justice Thomas, I got to say, the other thing that drove me crazy that he kept bringing up was, has ATF taken the position that these dealers are doing this and these purchasers are straw purchasers? Well, ATF is chronically underfunded every year, and for most of their existence, they've had an acting director because it's so politicized. It's hard to get a director confirmed, and so ATF, it might be a decade that they can't do an audit of a dealer. So, and he knows that. He knows that they have limit. And I know that there's people out there who ATF is the agency they love to hate. But ATF has always been operating on a skeleton crew, and Thomas knows that. And the fact that they didn't want to weigh in on this case or get involved, to me, isn't that important or wasn't that good of a point for him to bring up.
But I guess, it gets to the deeper point of like, you have to show that someone is breaking the law here, but it's not clear that it's necessarily the dealers or the wholesalers or the manufacturers. Right? I guess that's one of the big
and
problems.
So this one of the things that I'm kind of wondering if we're going to get is that in this opinion, when it comes out, is that they kept focusing on you needed to specify who did what in your complaint. Mm-hmm. And in a sense, they're kind of telling Mexico or other people that want to sue the gun manufacturers how to draft their complaint next time, right? And so sometimes an appellate court will reverse someone's case. I've seen the Supreme Court do this in the past, where they basically rule against someone, but basically, if you read the opinion, it tells them how to win next time.
Yeah.
And so don't wait and just think you're going to bring all of this in at trial. You need to name names in your complaint, and then we would have let it stand. And so
Yeah.
the
I mean,
companies,
that makes sense because, like you
Right.
said, conservative justices here it didn't feel like they were of the position that you can never sue gun makers. They just want to see like evidence that the gun maker knowingly was helping with criminals carry out either through ignoring straw purchasers or what have you. But a lot of it seemed like they want more specificity.
That's right.
In a suit like this, if you're gonna get especially given that there is a law that specifically is trying to block certain kinds of lawsuits, right?
Right.
So yeah, that would be interesting. Like maybe it will be a ruling that's like, this case doesn't work, but if you had X, Y, Z, it could work. Is that what you're thinking?
And I got to tell you, so for me, I like PLCAA, I like the predicate exception, and I was afraid when they agreed to take the case. And you were right earlier if you indicated that the fact that they took the case was bad for Mexico.
Yeah, that's what I was thinking when they took it up, because it's like if they agreed with the lower court, they could have just
they could have just let it go to trial and then dealt with the case after the evidence,
which they did in the Remington Sandy Hook case. If
that's
you recall
right.
That
they did, and they have done that before. And by the way, it's still possible. Every term now they've in a handful of 2 or 3 cases. They have, after oral argument, regretted taking a case and dismissed it. The word is dismissed as improvidently granted. So it's technically possible that if they decide, you know what, we shouldn't have even taken this case, let's send it back and let it go to trial, and then they'll get rid of the case on summary judgment or something for not being able to give the proof. So I think there's a non-zero chance of that.
That has to be a small percentage.
That's why I said non-zero.
Yeah.
And there's also a non-zero. So a few of the justices really went on this extended discussion about the distributor intermediary problem here.
Right.
And that they thought Mexico, so it was pretty clear from, I thought, oral arguments that they thought Mexico's case was weakest against the distributors. And I think that there's a small chance that some, and I don't know if they'll get to 5, are going to say we should dismiss this as regards to the distributors because they didn't allege specific enough facts that they knew that they are aiding and abetting or that they're accessories to this. But we're going to let them proceed with putting on evidence against the manufacturers. It's not inconceivable that we could get some of the justices saying that. And
why do you think that when the manufacturers are even another step removed from the distributors?
Because the distributors have in some ways, so they can't do product design as much. They're not the ones that are contacted with when there's gun traces from law enforcement. It's going to be the manufacturer. And so it's a little bit.
I would think the distributors are involved in that as well, because you're
maybe
tracing back through.
Maybe I'm
the sale
mistaken. If we're doing it based on serial numbers, they contact the manufacturer, and then they go through downstream through the distributor and to the retailer and try to figure out who purchased a gun.
Yes.
But it could be that they just didn't. You would have to allege. Make a more specific case about what the distributors know, and to get this. And so the question is, is it easier to argue that the manufacturer could instruct the distributor, we're going to switch to a different distributor if you don't run a tighter ship and control which retailers you're dealing with, or something like that. And the question is going to be how, and this was what they kept harping on at oral argument. They're not sure that distributors have as much information as the manufacturers. And so we'll see what happens with that. I want to say something about Justice Alito. Justice Alito in recent years has kind of become notorious for being a little rude to whichever side he doesn't agree with, to their lawyer, and sort of mocking their position or argument. And one of the surprises yesterday was that he didn't do that. He, in fact, at one point, his last comment was that to say that this raised very interesting, thought-provoking questions about criminal law, about aiding and abetting and proximate cause, and that both sides had done an excellent job with their briefs and arguments. And that's, from Alito, it's kind of a banner day if you get a compliment for whichever side he's ruling against. So I don't think that he thought that he at least thought Mexico's lawyer did the best that anyone could do in this situation. I'm not sure he thought that Mexico's case was ridiculous. I think that he was recognizing that causation is a very complicated philosophical problem when you start getting into it. And aiding and abetting is too, because they both involve drawing lines, and that depends on facts. But we don't have a trial yet, so we don't have all the facts, but maybe we should have to spell out some facts and so forth. And so there are difficult issues there.
That's a good point to bring it back to the standard we're talking about here, because these justices are not deciding whether or not they think Mexico's merits claims are correct. They're just deciding whether or not they've reached the bar to be able to move forward to making a merits claim.
That's right.
You could get people who you get justices who think that the case is not going to be won on the merits, but that there's enough of a concept here for the case to meet that exception in the PLCAA. I think we both agree that's not likely that's how it'll come out, but it's just important to remember what we're talking about as far as these justices are listening to a legal argument about whether these claims fit this exception, not whether or not these gun companies should actually be held liable based on the evidence that Mexico would have to present. So it's a sort of a different conversation you're having, right?
It is.
It might produce some surprising results.
It could, and it's a problem where we have a statute. So we have actually a legal text that we have to interpret beyond just saying, who do we think should win this case? Right. On that note, though, I'm going to poke fun at a couple other justices. A couple of them kept bringing up, should we hold knife manufacturers liable and baseball bat manufacturers liable and so forth. And I think I understand why that's the rhetorical effect of that, but it's not the same at all, right? So we don't have a baseball bat tracing apparatus in place like we do for gun traces or for knives. So if the police recover a knife from a gun scene, they can't trace the chain of custody back to the manufacturer the same way they can with a gun. And the fact is, you can sue. We don't have PLCAA for knives. So you actually can sue a knife manufacturer or a baseball bat manufacturer if you can show that they are knowingly and deliberately selling truckloads of them to a drug cartel or something like that. And so that's the other fallacy of that is they don't have immunity, and PLCAA.
Well, you can sue gun manufacturers if you can show they're knowingly selling them.
I agree. Except these other products that you could get in trouble for selling to criminals aren't covered by PLCAA.
Right, they don't have the same legal protection.
And so the problem is we have a text, and the question is, should we decide every case on which party we like more, or do we need to be strict constructionists about the text and textualists and stick to what the text said? And that's part of what's going on in this case. I mentioned in my thread, they also brought up the car manufacturer, can we hold car companies liable? And as I said earlier,
there's a common metaphor.
That's right. And when I was in practice years ago, 20, 30 years ago in Connecticut, I was told that we actually had a state statute that rental car companies were strictly liable for accidents that people committed. And so, and we do, I mean, the car companies are in litigation all the time for accidents, that wrongful deaths by third parties that get hit by the car because of the brakes failing or the tires blowing out or something.
But that's similar to the defective design lawsuits you can bring against gun manufacturers. Right?
It is.
The argument you often hear is you can't sue Ford because a drunk driver hit you with a Ford, right? That's more what you tend to hear.
That's right. And so we have this question of the intervening cause issue, and it's a valid point, but there's arguments both ways, right? So Ford isn't making something that's basically designed primarily to be a weapon to cause a fatal injury. And I don't think we can deny that that's what the gun manufacturers aren't making beach balls, right? They're making something that's useful for self-defense or
criminal actions.
Right. Exactly.
Although that's where the criminal act by a third party that you're not involved with is where a lot of people will draw the line.
And I understand that. Yeah.
But like you said, the case here is more about you just sort of whether, because they know that these guns are, some of them will end up in cartels, is the process that they're, even though they may be abiding by all American gun laws, is the way that they're doing business leading to that, and they are aiding and abetting that process then by relationship of those things. That's more or less the argument that they're getting into, and I think, we can agree that the majority of the justices probably aren't going to go for that, but it may be a more interesting opinion than on first glance listening. Is that sort of bottom line?
Yeah. I was worried when they took the case that they were going to interpret aiding and abetting so in such a way that it would make the rest of PLCAA it would basically make it impossible to sue a gun dealer, no matter how bad they were, right? No matter what they did. And I don't think we're going to get that. So we're not getting my worst case scenario, which is that they would somehow make things worse than PLCAA already is, or give or give some sort of super immunity so that gun dealers are like somehow above the law or can't be ever held responsible no matter what they do. It was pretty clear yesterday in the oral arguments that we're not getting that. There were several conservative justices who are concerned about people supplying guns to criminal organizations. Sure. And deliberately and
I think there's I think that'd be a pretty popular position generally. Like if you knowingly sell guns to criminals, you should be sued and arrested and charged. Well, really, you should be criminally prosecuted, right? For most people.
And I agree, and that's why they were able to get the predicate exception passed with the statute. Sometimes,
but they're also probably not going to draw they're not going to expand the predicate exception to fit these more vague claims just non-specific claims. Like they have an outline of how the process works, but they don't have specific accusations of, or at least in their
let me give you an example.
Specific accusations of how the Smith & Wesson was like actively involved in specifically aiding and abetting, I guess it seems like where they're headed.
So if I can go back to the case with Soto versus Bushmaster, the case about the Sandy Hook ones, in that case, because they decided not to take it and to let the Connecticut Supreme Court's decision stand, the Connecticut Supreme Court basically said you can be violating state marketing laws and by marketing your guns to criminals for criminal activity, it fits under the exception. And so, as you probably know,
and they were very skeptical that they'd prove that on the merits, and it never did get to the merits.
That's right. But what that did was it gave a blueprint to a whole bunch of states to adopt statutes that were tailor-made to avail yourself of to sue gun manufacturers and work under the predicate exception.
Mm-hmm.
And what we're going to get from this case might be another blueprint for how exactly to bring a legit case. And in that sense, there might, for the people suing gun manufacturers, there might be a silver lining to this.
Although that is another reason that maybe they took this case up. Maybe they regretted not taking the Remington case at the time. Although it was a different court then as well.
It was.
Slightly different, at least.
It was a different court and a different administration, a different political climate about guns. Yeah. Everything is different.
We'll have to see exactly, because that might be in some of their minds. Like, maybe we don't want to put down a blueprint for how to, sue gun companies necessarily, or at least we want it to be a very narrow one. So we'll see. I definitely agree with you that it'll be interesting to see exactly what the opinion is and how it shakes out. Because I still feel like it could be fairly lopsided, but maybe it'll have we'll get a lot of concurrences.
Yeah,
like you suggested.
I'm expecting what I call a splintered opinion or fractured opinion. And the problem with those is forever after there's a debate about what does a case stand for, right?
Yes.
So if we had 7 different opinions, in Bruin, what does Bruin really stand for? So
right. Yeah,
right.
It is an issue. If the court doesn't speak as one, you're always going to be wondering exactly what they meant, and you'll probably just need more cases down the line to figure it out.
That's right.
Hey, I appreciate you coming on. We went for a little longer than normal, so I thought there was a lot of interesting stuff to get into here.
Yeah.
If people want to follow your writing, where can they do that?
So if they can Google me, I have their ssrn.com. If you go for Dru Stevenson, Drury, it has all my articles and papers listed for free download. That's all right. Yeah.
Wonderful. Well, I appreciate you coming on and giving your perspective on this, and we'll have to have you back on in the future. We'd like to get a variety of points of view here, so appreciate you doing that.
Thanks for having me, Steve.
All right, I'm gonna hand it over to myself to tell you guys a little bit more about the dispatch as we continue our ad swap this week. All right, folks, it's time to talk a little bit about the dispatch, doing an ad swap here between the Reload and the dispatch. And I think that's fitting because if you like what you're getting from the Reload in terms of high quality reporting that focuses on hard news, you'll probably like the dispatch as well, because get this, they also focus on high quality reporting and hard news. Now, they are a much broader publication than the Reload. We obviously focus on one specific area, whereas the dispatch has a much larger team and is able to focus on a whole number of other issues, but still primarily in that national politics realm like we do here at the Reload. But they are one of my favorite publications. I am a paying member to the dispatch. And so clearly, I highly recommend it. I've been a paying member since they were founded, and I've never had reason to rethink that even once. So they are constantly breaking news stories. They are sending you newsletters on whatever frequency you want. They have quite a variety of them over there. But I subscribe, for instance, to the Morning Dispatch, and I get, I think, a very nice summary of what's really going on from a pretty sober perspective. That newsletter is hard news, and it's focused on it, and I think it's fantastic. But they also, of course, have some of the best commentators, in my personal opinion, over there as well. It was an outlet founded by Steve Hayes and Jonah Goldberg, 2 guys I've known for a long time. They've been on the Reloads podcast. Kevin Williamson as well has been on our podcast. So you've heard from these guys if you've been a Reload listener for a while here. And, I think you should check out the dispatch if you haven't already. We have a free trial as well, 30-day free trial for Reload listeners if you want to go over and check out their paid offering, which I think is well worth the money. So I'd encourage you to do that. There's a link in the description of this podcast or on our website if you want to check it out. So head over to the Reload or to get that link, or head over to the dispatch to see what they're all about.
No, the devil's got no